Water's full.
No, you ready? One way or the other.
Maybe that way.
Yeah, because I think
Is that okay?
Shining it on you.
I think it's blinding. If you put it the other way, it's blinding over here.
Yeah, exactly.
Yeah.
All rise.
Good afternoon, my lords. Before the short adjournment, I think we were on the specification list. And what we say about that essentially is three things. We say, first of all, the court below had to manage on the basis that the document had not been disclosed. And notwithstanding that fact, the court below made its finding that the inspection and clearage of the drainage channels was part of the service. Secondly, that finding is not challenged in this court. So with respect, we submit that this court should also proceed on the basis of that finding, because no specific challenge has been made to that finding. And in any event, we would say that even if the appellant sought to challenge that finding, which it doesn't do so, the appellant would be barred from doing it for two independent reasons. The first is he didn't seek to make that challenge below, and it could not have made that challenge below because it concerned evidence given by its own witness, by which it is bound, irrespective of whether Mr. Roberts is an independent witness. He's still a witness who was called by GVE, and therefore GVE is bound by the evidence which it is called. And secondly, it would in any event be unfair to do so, because GVE has withheld the document in question from disclosure.
Your point is they don't challenge their own experts' evidence.
Yes, they don't. Indeed. Indeed.
Can you just clarify one thing, which Mr. Levy made the dangerous observation that we should use judicial common sense, which is extremely dangerous, but the service A and B, I think, are generic, applied across all Mercedes brands. When you have a specific car, there may be additional requirements, and it's that which Mr. Roberts was referring to. So the A and the B, as we understand it, would apply to almost every Mercedes car of whatever type. And there are these incremental service instructions for different types and different models.
Yes.
And it is that which is withheld. And that explains why the document we've seen doesn't refer specifically to anything to do with drainage channels. It wouldn't be an issue arising generically across Mercedes estate car or Mercedes saloons, so on.
Well, my lord...
That's as we understand it. I say that's the danger of using judicial common sense and leaving us to look things up over the internet. But we're not going to give evidence ourselves. We just want confirmation from you that that's the case, if we got that right.
Well, my lord, I'm not myself in a position to give that confirmation,
right.
Because it's simply something which is outside my own knowledge.
Right.
No.
But you can sort of deduce it from the service sheets which we have seen at 215 and onwards, because they
Yes.
are clearly generic. Because the model, I think,
Has to be filled in.
has to be
Yeah.
filled in. It's not pre-printed. You know, it's not a specific sheet
Yes.
to the
Yes.
the model itself, I think.
Yes. Yes.
And the A and B service, I'll confess, seems to be, as it were, the level of service generically that you can pay for.
Yes, no, I do recall having read in the papers, but it may be the case that I can be assisted by those behind me, that service B refers to a more substantial service than the service A.
Yes.
And I think that is somewhere in the papers. And it is right, of course, we can take notice of this fact, that the issue in relation to drainage channels, of course, is a feature or an issue in relation to convertible vehicles, at least. Whether it applies to all Mercedes convertible vehicles, I'm simply not in a position to know, and there's not been evidence on that. But it is a convertible issue because plainly one doesn't need to drain through the bodywork when one doesn't have a roof that needs to fit flush. That's the issue which Mr. Roberts gave evidence on. My Lord Justice Snowden observed before the short adjournment that of course, you know, it does beg a question as to the potential incompatibility between, or tension between, the specification list and this generic service B schedule, or the service B record, and that might be an explanation to it, and if so, we would adopt it, but we would venture to suggest that this is precisely the reason why great caution has to be exercised with regard to an appeal against a finding of fact, because the difficulty is that there could be a lot of speculation that one could inquire about, and it might be then necessary to put those sort of questions to a witness, and it might be necessary to go off and make further inquiries, but the reality is the judge has made the findings that he has made on the basis of the evidence before him, which nobody is seeking to go behind now, and so we respectfully therefore rely upon that finding. And we say that it in fact goes slightly further than that, because you were taken before the break by my learned friend to paragraph 6.7 in Mr. Roberts' first report, and that was a page in the first supplementary bundle. That was page 79, tab 14, and there was a discussion between my learned friend and the court in relation to the term evidently. He said it is shown in the provider's service history that Mercedes Shrewsbury carried out service on the vehicle on the 8th of May 2019 at 6,331 miles. At this point, Mercedes Shrewsbury evidently failed to investigate or successfully identify and repair the reasons for the water ingress to the vehicle interior, and Boot reported them on 24th February 2019 and 29th April 2019. Now, on its face, and we respectfully endorse the observations that the court has made, on its face, all that word evidently appears to refer to is the fact that because there was then catastrophic flooding in November, Mr. Roberts has concluded that the issue wasn't cured in May. So that would appear simply to be a statement of cause and effect, because he says it wasn't cured in May. Because he says that because there was a catastrophic failure in November, it wasn't cured in May. Now, first of all, that's a non sequitur. It's a non sequitur because, as I will go on to submit, and in fact, as the judge found in his judgment, the position is that the debris can accumulate within a period of less than 12 months anyway. So the position is that the drainage channel could have been cleared in May and then blocked again by November. So the first point is that actually is a non sequitur. But the second point is, in any event, Mr. Roberts' evidence was not consistent with it when he was cross-examined on the point. In that regard, we rely upon what he said in the transcript in cross-examination, which is in supplemental bundle number 2 on page 219. the bottom of page 219, which is behind tab number 3, indicating it was the third day of the hearing. Bottom of the page 219G, question is asked by the claimant's counsel. Now, before we come on to the specific events on a routine service, and we saw the checklist and we saw the reference to the underside, what would you expect the main dealer at Shrewsbury to be doing in relation to the matters we're concerned with? And I probably should say here, namely issues of blockage and accumulation of debris in the drainage channel. And the response from Mr. Roberts is, certainly, even if there'd been no reports of water ingress to the vehicle, I would have expected, as part of the underbody inspection, that the drainage channel outlets would be checked for blockage and that any blockage removed whilst the vehicle was on a hoist and the underside was being examined. I would expect that to have been carried out as a matter of course. And his words there, as a matter of course, reflect the words he used in his supplemental report, which I referred to before the short adjournment. In the supplemental report, he said, as a matter of routine, when a vehicle is brought in for a scheduled service and inspection, there will be clearing of the body drains. So his evidence in this regard is actually consistent, and the reference to that was in supplemental report, which was page 100 in supplemental bundle number 1, behind tab 15. So the starting point is that even if there'd been no reports of water ingress, as a matter of course or a matter of routine, he would expect this check to have been carried out. Counsel responds yes, and then Mr. Roberts goes on, as a matter of course, as part of the underbody inspections, certainly with the reports of water ingress to the interior of the vehicle, I would have expected any repair organisation to check the drainage points both at the front and the rear of the vehicle. The scuttle drains, certainly to the point of what they subsequently, Mercedes Shrewsbury subsequently appeared to have done, that they identified where the water was collecting. So yeah, if they were informed, if the technician had been informed of the problem with water ingress, I would have expected them to have been carried out. So Mr. Roberts' evidence actually on the particulars of this case, rather than simply the cause and effect, is he would have expected the check to be made anyway, but certainly if the position is that Mercedes had been informed about the water ingress. And we know in this case that Mercedes was so informed, because that was the evidence that was given by Mr. Clapton, and also corroborated by the evidence of my client, Mrs. Kynaston-Mainwaring. And the evidence of Mr. Clapton was in supplemental bundle number 1 in his witness statement at tab 20, page 150. Page 150, he says, so that the position is that amongst other snagging issues to do with the car, there were some bodywork repairs that had to be done, and that's the business which is Mr. Clapton's business, is the director, it says on page 1, of RSC Body Centre Limited. So when the Mercedes was brought in, he says, paragraph 12, we carried out the bodywork repairs to the Mercedes, which were paid by GVE. He says he oversaw the work done by his panel beater, Mr. Tom Lowry, and that when carrying out the work, paragraph 13, Tom called me over to show there's water in the boot. I can recall seeing water in the boot for myself, but due to the passage of time, I can't recall exactly how much water was there. When I saw the water, I also saw that...
It's the last sentence of paragraph 15, isn't it?
Yes, yes.
So, I mean, I don't know whether we need to have all the rest of the stuff read to us, but...
We saw it this morning.
Yes.
Yeah. I mean, it didn't feature on the service sheet, but that's the evidence.
Yes, exactly, my lord. And we say therefore...
Was he cross-examined?
Mr. Clapton was cross-examined, yes. I'm not sure whether he was actually cross-examined on this particular point. But in any event, the judge, as I understand it, doesn't find that Mr. Clapton's evidence is to be disbelieved. And of course, Standing back from it, the grave difficulty, which I confess, of course, I'd fallen straight into the trap as soon as I stood up on my feet. The grave difficulty here is that the judge has heard all this evidence. The judge is not expected in his judgment to set out every single piece of evidence he's heard. It would be a quite impossible task for him to reflect not only all the evidence he's heard, but also those parts of the evidence which were given in witness statements which he accepts and which he doesn't accept. And it's an even more impossible task in this case, because the trial was conducted, as my learned friend rightly said, on the shorter trial scheme. It was an extempore judgment, and what's more, it was an extempore judgment delivered in a matter of hours after closing submissions, on the same day as the closing submissions. And so we say, in those respects, it'd be quite unfair to presume against the judge in circumstances where he might not have made a particular reference to any particular part of the evidence or dealt with it in the same depth as we may be inquiring into in the course of this appeal hearing. Or we say, standing back, that therefore the appellant's case has three inherent improbabilities. The first is that Mercedes-Benz lookers, professional service technicians, licensed, we understand, by Mercedes-Benz, would simply not have done their job correctly, and moreover, would have done their job negligently. The position is that it was a specified service, part of the service that had to be done to check these drainage channels, and it wasn't done, and as a consequence, a car suffered catastrophic damage. A £122,000 car became, in the evidence of my client's expert, Mr. Law, only worth £8,500 for scrap value. That's a service which, on its face, would have been carried out negligently. So that's the first improbability, which is that Mercedes-Benz didn't do their job. Secondly, it's inherently improbable that when Mercedes-Benz did the rest of the service, according to the service sheet, what we can see, the underbody inspection, that it wouldn't have done this part of the job. Why did they leave out this particular thing? But that has to be the appellant's case. And thirdly, the third inherent improbability is that Mercedes-Benz did this having been informed in particular about the problem with water ingress into the vehicle, against a background of the appellant's own witness, expert witness, Mr. Roberts, saying that in no circumstances he would certainly expect the underbody inspections to have included checking the drainage drains. So there are three inherent probabilities with the case which is being advanced by...
They're not really three inherent improbabilities, are they? They're all aspects of one inherent improbability.
Well, my lord, yes. I said that.
The inherent improbability is that they would not have done what they were supposed to do in these circumstances.
Yes, I think that it must be.
And then all you're enumerating is different aspects of the circumstances.
Yes, that must be correct. I think perhaps I could recharacterise it saying that it becomes even more improbable by reason of the two further factors.
Yeah, but it's not as though there are three cumulative aspects,
yes,
each of which has to be overcome. It is that there is one situation where you say it's inherently improbable that they did not look at to deal with the drains.
Yes.
But you don't have to go anywhere near that far. All you have to say was the judge was right to say on the balance of probabilities, they did.
Well, yes, and in fact, I would respectfully suggest I don't even need to go that far, because I don't need to. I don't need.
Yes, I understand. Yeah.
So, and that is the context against which my learned friend's approach to this evidence, we believe, should be put. In essence, he advances in this court, I think, 4 points about the maintenance schedule, the maintenance in May. He says, well, some internet research has been done, and the internet research didn't come up with any other vehicles with the same problems. He says that there was a short passage of time between May and November when there was the catastrophic flooding. He says the vehicle was well looked after, and he says, which I think really is the same point as the internet research point, he says there are other vehicles of the same model, and he's not, or the court was not made aware of any fault in those such vehicles. And we say that actually those 4 points or 3 points are just irrelevant if one starts from the proposition that there is some evidence which supports the finding the judge made, and that evidence is that it's on the specification list. We know that a service was done, and the service was done by a professional service technician or service technicians. And so we say that even if there was any substance to those 3 or 4 points, it wouldn't, with respect, get the appellant anywhere, because if they would still be confronted with the impossibility, we say in these circumstances, of challenging a finding of fact on appeal. And my Lord Justice Snowden asked my learned friend about the correct test in that regard, and if I may, without wishing to exhaust the court's patience in a fairly well-trodden area, but if I may refer to an authority in that regard, which is the Whedon case, at Authorities Bundle tab 12. And it's in the relevant passage on which I rely begins on page 235. The first passage is the well-known, or citation is the well-known part from Page and Chivani, which Lord Justice Coulson in this case quotes, and then
This is a PTA, permission to appeal case.
It is indeed, my lord. It's the judge. The judge adjourned an application on the papers for permission to appeal for it to be heard at a hearing in order to address the appropriate test for appeals against findings of fact in the Technology and Construction Court, and amongst other things addressing whether there's a different test which applies to a TCC appeal as opposed to an appeal generally to this court against finding of fact. And Lord Justice Coulson held, amongst other things, that there is no difference. And here he set out what we respectfully suggest are 3 of the leading and most recent authorities in that regard, and we particularly put reliance upon paragraph 8, where there's a quotation from the Henderson case, Henderson of Foxwood Investments in the Supreme Court. It follows that in the absence of in the judgment of Lord Reed, it follows that in the absence of some other identifiable error, such as without attempting an exhaustive account, a material error of law, or the making of a critical finding of fact which has no basis in the evidence, or demonstrable misunderstanding of the relevant evidence, or demonstrable failure to consider relevant evidence, an appellate court will interfere with the findings of fact made by a trial judge only if it's satisfied that his decision cannot reasonably be explained or justified. I'm pausing there. My learned friend, as I understand it, is not even seeking to come within any of the limbs of this test that Lord Reed has identified. It's no suggestion there's been a material error of law. There's no suggestion that there's been a critical finding of fact, which has no basis in the evidence. He's referred to some speculation, but he's not saying that the court made a finding of fact, and he can't do so on the basis of that passage 130 to 133 in the judgment. There's not a suggestion that there's been a demonstrable misunderstanding of relevant evidence or a demonstrable failure to consider the relevant evidence, because my learned friend, when he refers to the fact that internet research has been done or was a short passage of time or the vehicle being well looked after, that's all evidence which was before the court. It's not a new point which the judge has ruled out and not relied upon. And it certainly can't be suggested, the fallback position, that the learned judge's judgment cannot be reasonably explained or justified. I mean, the logical chain of reasoning is set out in the judgment. It's simply that my learned friend says that more weight should have been given to the points which he's now pressing before this court. And in paragraph 10, over the page, on page 236, Lord Justice Coulson says, in short, to be overturned on appeal, a finding of fact must be one that no reasonable judge could have reached. in practice that will usually occur only when there was no evidence at all to support the finding that was made, or the judge plainly misunderstood the evidence in order to arrive at the disputed finding. And I'd hope my learned friend would accept that, even put at its highest, he's not arguing that case. He's not saying that this is a decision that there was no evidence at all to support the finding that was made. Simply saying that there should be greater weight given to the factors which he's now seeking to identify. And there's no suggestion that the judge plainly misunderstood the evidence before him. Simply that the appellant disagrees with the judge's assessment of that evidence. And in paragraph 11, the court, Lord Justice Coulson, goes on to address the question about expert evidence, because of course my learned friend is relying upon paragraph 6.7 of Mr. Roberts' first report. And the learned judge says, at first instance, paragraph 11, at first instance, judge's assessment of or evaluations based upon expert evidence adduced at trial must be approached by an appellate court with similar caution. Whilst it has been said that reconsideration of an expert's opinion may be slightly easier than a finding of fact because the underlying report will be in writing, the same case also provides a salutary warning that since the evaluation of expert evidence is likely to be bound up with a wider evaluation of matters of fact, an appellate court will be still be very slow to interfere. And then the warning in relation to cherry-picking parts of the evidence, which was each a subject of oral expert evidence which the appellate court has not heard, is then made by reference to the Thompson case and the decision of, or the dictum of Lord Justice May there. And so we say that the starting point and frankly the end point is, provided that the specification list is there, provided that the service was done by a professional service technician, then that is the end of the matter, because my learned friend is not pressing, and the appellant can't press any case to the effect that there was no evidence, there was a complete misunderstanding of the evidence, or that this decision was one which no reasonable judge could possibly have made. And we suggest that if such a point were taken, it would be manifestly unfair to the judge who was seeking to deal with the evidence that was before him in a case where he hadn't been provided with all the relevant documents and simply had to do the best he could with the information that was made available to him. And so we say that the position in respect of each of those four factors, internet research, short passage of time, well looked after, and some other vehicles, can't move the needle anyway. But if we're wrong on that, and it is necessary to consider these individual factors, it's worth actually looking at how far the evidence in question really went. For example, in relation to the internet research that had been done by Mr. Roberts. So if we go to Mr. Roberts' evidence in bundle number 1, supplemental bundle number 1 at page 177, I think is the starting point. Page 177G at the bottom of the page. Behind tab number 2. At the bottom of the page, in respect of G, Mr. Roberts refers to, he's asked about his role working at Honda, says he's responding to customer concerns about designs that involve helping advise Honda on how you respond to customers saying that a Honda car doesn't work.
Can I stop you for a moment? I've lost the reference, I'm sorry.
So
no,
it's SB2, not SB1.
Oh, SB2.
I apologise. Sorry, my lord.
And the page again was...
It's 177.
177, thank you.
In the transcript, cross-examination of Mr. Roberts.
Thank you.
So he's asked about his role, because the point made by my predecessor in respondent's notice is that Mr. Roberts does actually have some expertise also in relation to this issue, or bearing upon this issue of complaints about vehicles and what manufacturers do in circumstances where they receive complaints about vehicles, because he had a role at Honda which involved having to consider such complaints. And over the page, at page 178, he's asked, so in that particular role you weren't involved in so much in advising Honda on how they should design a car before they put it out there. You were concerned more with looking at what customers who bought a particular model have been saying about it and the issues that have been reported by customers. And then he goes on to say that he was part of the new model development team. And then the question is asked, if a concern is raised about a particular model, is it something which may or may not result in change to the design of the next iteration of the model? And he says yes, based on a number of factors that are weighed up. And then he's asked, and that process of collating what customers are saying about an existing model and considering whether you make change to a future model is presumably very confidential to the manufacturer. Answer completely yes, yes. And then he's asked whether the same degree of confidentiality would apply to Mercedes as it did to Honda. A reasonable assumption, and Mr. Roberts agrees that would be a reasonable assumption. Then he's asked, and if somebody in the position of the claimant wanted to find out from Mercedes how many people are complaining about drainage channels of a particular model of AMG, Mercedes are not going to let that information out, are they? I would not expect them to know. So there's evidence before the court that this is a confidential matter in any event. This isn't a matter that the court needs to take judicial notice of. There's evidence was given by Mr. Roberts, and the appellant is bound by that evidence in that regard, albeit that the evidence simply reflects common sense. And one recalls the part in the judge's judgment in which he says, well, until the point at which it may be necessary for a manufacturer to have a product recall, it may be the case that this sort of information would remain confidential. And so the judge's judgment in that regard is in fact supported by the evidence that's been given by Mr. Roberts. And then he goes on, he's asked about research at the top of page 179. And he's firstly asked about research about the boot spoiler, which is the water getting into the boot from the boot seals not fitting. And he's asked, what was the research? It was purely an internet search where I did come across more than one report from different sources of a similarly described situation, specifically on Mercedes AMG GT. Did you do similar research in relation to the block drainage channel? Yes. What was the outcome of that research? The outcome of that research was I did identify some internet forum comments which I perceived to be related to the claimant. I didn't find anything in addition to those forum comments. And he's asked, is there a reason why you didn't mention that research exercise in your first your first report? He says, I wasn't asked, I didn't feel that it was relevant. So the high point of the appellant's case on internet research having been done is some internet research which my learned friend characterised as a Google search. I mean, that may be true, but we have absolutely no particulars in relation to what was actually done by Mr. Roberts. This could have been 30 seconds worth of research, and certainly he didn't consider it necessary or relevant even to put it into his report. So we don't know what has been done, and one cannot proceed on the basis that there simply are no complaints in relation on the internet in relation to vehicles of this type or in relation to complaints in this regard. All the evidence that was before the court below was that which happened to be given in the course of cross-examination rather than in any particular report. And then Mr. Roberts' perception that what he found was related to the claimant's case and not to any other case. So that's the height of the
significance of, let us say, a consumer forum in which there was a discussion about drainage problems in circumstances where it's part of the system that such drainage problems as arise, it being a recognised problem, are dealt with by servicing. You could have all sorts of comments, but it wouldn't tell you anything about whether it was a systemic defect or not. It would just tell you it was something which needed to be dealt with by servicing.
Yes, indeed, and it may be the case that that these problems are resolved by servicing, and nobody feels the need to mention it on the internet forum. But even if they did, it's rather bewildering how that would assist the judge below. And so the judge below really going to change the findings he's made on the basis that Mr. Roberts reports that he's seen something on the internet. mean, that seems to me to be improbable, and in any event, not the relevant exercise. The target which the appellant has to tilt for is to say that in the absence of any reports on the internet, it must be assumed that this is the single case in which this incident or this problem has been reported. Well, that's not what the judge found. What the judge found is the Carl Sagan point that absence of evidence does not equate to evidence of absence, and that, with respect, was not only correct on the basis of the evidence that was before the judge, but also just avoided the judge falling into a basic logical fallacy, which is to say that because there was no evidence before him, it follows that the report had never been found before. And that is before we get to my Lord Justice Phillips' point, that in any event there must be a first case anyway. So the internet research point, which seems also to be the same as the other vehicles and no fault has been reported point, we say doesn't take them anywhere anyway. And the next point is that it said, well, it was just a short passage of time. It was just a short passage of time that passed between May and November 2019, and because it was a short passage of time, therefore it must be assumed that the blockage wasn't cleared. But that assumes something completely different, which is not on the basis of any findings made by the judge. That assumes that there's some sort of linear progression whereby debris gradually accumulates in the drainage channel until it becomes blocked. So the drainage channel can only become blocked over a period of time. But that's not what the judge held. The judge held that the position was that the drainage channel could become blocked in a period of less than 12 months. And the basis for the judge's finding in that regard was the February and the May 2019 incidents. So what the judge found was that the February and April 2019 incidents were caused by the water ingress incidents, were caused by the blockage of the drainage channels. And of course, the February and April 29 incidents occurred within 12 months of the vehicle having been serviced in May 2018. And the judge held, and it was in fact GVE's own case, that the position is that the service in May 2018 was correctly carried out. So the judge's reasoning is, if the service in May 2018 was correctly carried out, therefore the drainage channels were not blocked in May 2018, but the drainage channels were blocked in February 2019 and April 2019, it follows that the drainage channels couldn't become blocked in a period of less than 12 months. That was the judge's analysis.
I think the criticism which was levelled was slightly different, though, wasn't it? Wasn't it that the judge, in answering the point, in refuting the point that the argument that it wasn't cleared in May, recognised that, well, it was odd then that nothing happened until November.
Yes.
But didn't then recognise that there was a ready answer to that, in that the vehicle wasn't taken out and exposed to the risks which might lead to it becoming blocked. And so that was the point that was made in relation to that time gap.
But the difficulty with that is that that assumes a premise, which is that the vehicle would have to be run for a certain number of miles or for a certain period of time between May and November in order for it to accumulate enough debris that the drainage channel could become blocked.
Well, I think, of course, I understand that, but I think on the judge's finding, it was cleared in May, but then I think the point Mr. Levy makes is that there was no opportunity identified for it to be become blocked again by November.
But there's no evidence, as far as I'm aware, that the vehicle was off the road between May and November.
But I think the point is the evidence is it was on the road very little.
But
Kept in
even
the garage and kept in the garage. I mean, I'm not saying it's right or it's wrong. I'm just that, as I understand it, is his point in this regard. And it's not actually about a short passage of time. I think his point is it's quite a long period of time.
I think we were told May to September, just under 1,300 miles, I think, 1287 miles.
yes, but again, the difficulty is that on the evidence that's available before the court, it could be the case that running the vehicle on one occasion between May and November could lead to the drainage channel being blocked, because we don't know, and we don't know, and one can't accept the position which is that the drainage channel can only become blocked over a period of 12 months or over a period of a certain number of miles being done. So there's a premise which underlies this point, which is that the vehicle wasn't used very much, which is missing, which is it have to be said that there was some linear relationship between the drainage channel becoming blocked and the amount of miles that were done, or the amount of time that the vehicle was on the road, or the conditions that the vehicle was being driven in. And there's simply no evidence to that effect. Yeah. And the position, in fact, is that Mr. Roberts declined in evidence to identify where, what the chance was of the vehicle becoming blocked or the drainage channels becoming blocked within a period of 12 months. He referred to it as being theoretical explanations, I think, and then was unable to specifically identify when. It was to identify a probability that it would have become blocked during that period. And of course, it is the claimant's own, the appellant's own case that what happened was that the drainage channel was blocked in February, and the drainage channel was blocked in April by ingress of the drainage channels were blocked in February and April, and that caused the ingress of water into the vehicle on those two incidents. That was the case which they were advancing below. And if that's the case they're advancing below, then it must follow that the position is that the drainage channel can become blocked in a period of less than 12 months. How it becomes blocked, the rate at which it becomes blocked, there's no evidence for that. And that rather underlies the difficulty which the appellant faces, because ultimately the appellant is the one that must suggest the position is that the channel couldn't have become blocked in the period between May and November. I mean, that's what it's positively alleging now. So it must produce the evidence, and we say there's no evidence to that effect. So the judge's decision in that regard cannot be impugned. And the third point that is made today is it said, well, the vehicle was generally well looked after. But that really takes one nowhere, because again, there's no evidence to the effect that the reason the drainage channel became blocked in the first place was that the vehicle was neglected. The joint experts said that there was no evidence of abuse or neglect of the vehicle. That's in the joint experts' report that's in supplemental bundle number 1. The joint statement is at paragraph tab number 16, page 103 is where they identify the points of agreement. And yes, thank you. Paragraph number 6 on page 104. It is agreed that there is no evidence to suggest the vehicle has been used in conditions for which it was not designed for, or subject to any kind of abuse, neglect, or accident damage, which could have caused or contributed to the blockage of the roof drainage channel. So even in circumstances where the vehicle is well looked after, we know that there were incidents of water ingress in February and April and November. So it's difficult to see on what basis that it would be said that that should affect the judge's analysis. And
Again,
it's also...
forgive me, I'm not saying there's merit in it, but I'm not sure you're really meeting what the argument was. I think the argument on this was that the fact that it was looked after, well, the car was looked after, and I think in particular that it was kept in the garage is etc. I think all that's being said is that this is an explanation of why there were not there was not flooding between May and November, and in particular because there was very little opportunity for exposure between May and November. Mr. Levy would say strongly supports his contention that the drain wasn't cleared in May, and that's what I understand. That's what I understand the significance of the point to be. It goes to support his contention. If it flooded in November after so little use, it can't have been cleared in May.
And you can add to that point, if you look at paragraph 3 of the joint experts report, they describe the process by which this drain might become blocked, which is that smaller items of debris which enter the top of the drain tube could gradually accumulate at the bottom of the tube and eventually block the exit of the tube, preventing the water from escaping. So, that's the point that's being made, I think, as I understand it, by Mr. Levy.
Yes. Well, the answer to that is, again, it rests upon an evidential premise that's lacking, because it's not said that the vehicle was not being used at all. It's if the vehicle was off the road for the entire period of time, and the first time in which the vehicle came out of the garage was when it was parked outside in the rain between the 20th and 22nd of November, then it might be said, well, that is an important piece of evidence that the judge failed to take into account. All we have is that the car was well looked after and did a relatively low mileage. But it's not said that, as I understand it, that the car wasn't being used at all. And so, on that basis, the difficulty with this argument is it is a point which is being made now, which lacks the necessary evidence, even if it were a powerful point in and of itself. And we say it's not, because with respect, we consider that it's too much into paragraph 3 to say the position is that one can go from the word gradually to conclude that that it can't possibly become blocked between November and May if the tube was cleared in May.
We just had a bit of water ingress
Oh.
on the bench here, so you may have to pause for a second.
I was so excited I spilled my water.
The drainage is very poor on the bench.
It's all right, keep going. I'm dry.
I think it's underneath your file. I think it's.
Oh yes, it's not quite so dry.
Yeah. Yes, sir.
Dried off.
My lord, I'm glad, my lord, that we've at least resolved this water ingress or egress issue. Helpfully been reminded that the reference to major and minor services A and B actually is in the manual for the vehicle, which is at page 203 in the supplemental bundle number 1. This is an extract from the manual, and then about halfway down the page it says depending on the operating conditions of the vehicle, the remaining time or distance until the next service due date is displayed. The letter indicates which service is due. A stands for a minor service and B for a major service. A number or another letter may be displayed after the letter. So that goes to the proposition which I vaguely recall, that the difference between A and B was major and minor.
Forgive me, Mr. I didn't catch that page reference.
Sorry, it's page 203 in supplemental bundle number 1,
Yes.
behind tab number 24.
I was one page out. That's fine.
And also, I was asked rightly whether Mr. Clapton had been cross-examined on his evidence about reporting the fault to Mercedes-Benz in Shrewsbury at Lookers, and
It's to page 122, isn't it?
yes, indeed, thank you, my lord. Yes. Yeah, that's it's on 122 when he deals with what he reported to.
He just told them there was condensation in the car.
Yes.
He very fairly. And why should he? Couldn't say he'd said anything more.
Yes, indeed. And the difficulty is that if this were a point of great significance, then maybe the judge should have given more reasons in relation to his analysis of this particular point. But as it is, all one can say is that Mr. Clapton reported the matter to Mercedes-Benz. The terms in which he did probably doesn't matter, and on the basis of his having reported it to Mercedes-Benz, one sees the evidence of Mr. Roberts, and the evidence of Mr. Roberts is that, well, if that be the case, it's a fortiori that he would have expected Mercedes-Benz to have checked the drains when it conducted its underside inspection of the vehicle. And I think the passage which I was thinking of in relation to the incident, the drains could become blocked within a period of less than 12 months, is paragraph 129 in the judgment at page 86 in the core bundle. And the learned judge's initial responses as to why the incident occurred in November as opposed to any other time, because it might depend on when the vehicle was actually in the rain, which of course seems to be an eminently sensible conclusion to reach, but would have nothing to do with when the vehicle was being driven, how far the vehicle was being driven, or on what service. And then it says that we know from what actually happened, it was possible for this problem to arise between the May 2018 service and February 2019, because one assumes, and the judge assumed, and proceeded on the basis that in May 2019 the drainage channels were cleared, and says it's equally possible that it arose between the May 2019 service and November 2019.
Well, you say in your skeleton that that's the reason why it doesn't actually matter whether it was serviced.
Yes.
Serviced in May.
Yes. Well, that's my fallback point, which underlies all of this, is that if I were wrong about this appeal against a finding of fact in relation to what happened at the service in May 2019, we would still say the position is that the vehicle was not of satisfactory quality, because the drainage tubes, on the judge's finding, could become blocked in a period of less than 12 months. If the drainage tubes could become blocked in a period of less than 12 months, then it follows that the mitigant for the potential design defect, of course the mitigant is that there should be inspection at an annual service. The mitigant for the potential design defect doesn't work, because the service is only conducted annually, and because we know from the joint statement of the experts, I may give the reference to that, the joint statement of the experts, they agree that that it's only reasonable to expect this this to have been the clearage of the drainage channel to be conducted by a professional repairer. That's in supplemental bundle number 1, tab 16, page 104, paragraph 7. It is agreed that the clearing of the drainage channel, if it were to become blocked, can only be completed satisfactorily from the underside of the vehicle. It is therefore agreed that this operation can only be carried out when the vehicle is being serviced at a repairer, and would not ordinarily be carried out by the owner.
Well, and that's why there's nothing in the manual about doing it. The owner's manual we just looked at. There's nothing in it about doing this.
Well, my lord, I think there is a reference in passing to this being something which the drainage channel is being cleared. That's page 202 in supplemental bundle number 1.
Yeah.
Says to clean the water drainage channels of the windscreen and the rear window at regular intervals.
I think there was a bit of cross-examination, a bit of debate on the transcripts that I've seen about whether that actually refers to the channel that we're talking about, or
yes.
whether that's the rear window.
Yes.
Certainly not the windscreen, I don't think.
Yes. Yes.
As opposed to the channel that's around the retractable roof.
Yes. Yes. I think.
But again, the point is the judge went into that.
Exactly. So the evidence is here. This is the same evidence which the judge.
Yeah,
had.
and there's actually transcript. The judge was asked the questions about it. I think I saw in the transcripts.
Yes. There is reference to clearing of the drainage channels, but it's certainly the agreed evidence before the court was that this could only be carried out by a professional repairer and it should be done at the annual service.
Yeah, the point is you can't. It's not telling the owner to lie on his back,
yes.
or her back, and start ferreting around underneath the car.
Exactly. Indeed, what the joint experts say is that it's something that should be carried out when the vehicle is on a hoist, which I assume means it's been elevated up. The car has been jacked up, which is something which would be quite impossible for the average car owner to do anyway, even if they knew what they should be doing. And so, given that that's the agreed evidence, if it is the case, as the judge found, and not subject of any specific challenge in this court, if it is the case that the drainage channels can become blocked within a period of less than 12 months, then it must follow that the vehicle is not of satisfactory quality, even putting aside the May 2019 service issue. Because if one assumes, for the purposes of this argument, if one assumes that Mercedes-Benz lookers did fail to clear a blockage in the drainage channel, nevertheless, the position would be that the vehicle would have a defect latent and inherent to it, which would mean that at any point in the future, within a period of less than 12 months, the drainage channels could become blocked. And that would not be a vehicle of satisfactory quality. Because
is it not? I mean, what's the actual test? We haven't really looked at it, but is it that it's an absolute warranty that it will never happen, or that it won't happen in ordinary circumstances, or what?
Well, my lord, I'm not sure that one can really gloss it beyond what the words of the Act provide, which is in the authorities bundle number 1 at tab 1, page 7. And so the test in section 9 is subsection 2. The quality of the goods is satisfactory if they meet the standard that a reasonable person would consider satisfactory, taking account of, and then the 3 factors are then identified. At number 5, the subsection 9.5 is not relevant here. And so the question would be, does a car, for the present purposes, if we just look at at subsection 2 rather than the price, subsection 2b, does a car meet the standard of satisfactory quality if it is left outside in the rain? It may be the case that it fills with water and then becomes undrivable, suffers catastrophic damage to the electronics. That we know is what happened in this case, and we know the mechanism by which it happened. There's in fact, there's no dispute in that regard. So the question is, well, would the...
I suppose you only have to look at the factors in 3C, D and E, that if it's left outside and it fills with water, then it's not free from a minor defect.
Yes.
It's not safe and it's not durable.
Indeed. And we would also respectfully say...
And its appearance and finish is tarnished.
Well, indeed, and would also rely on A, because the fitness for the purposes for which goods of that kind are usually supplied. First of all, the car is supplied for the purposes of being driven. And secondly, one might also say it's supplied for the purposes of being parked outside.
Yep.
And the context here is that it's being parked outside in England.
And you didn't refer to 2B, but presumably you say, in a sense, on one view, the more expensive the car, the more justification you have for thinking this sort of thing shouldn't happen.
Indeed.
Although,
Indeed.
under C, one of the other relevant circumstances is if you buy a particularly sort of flash design car that's not your bog standard Mini or whatever, you take a little bit of a risk with form over functionality.
Well, my lord, I accept that, but only within reason. So I accept that if one buys a very expensive, there was my lord will have seen in the transcript, there's a rather arid debate about whether this vehicle counts as a supercar or not. Well, I accept for these purposes that if one buys a high performance vehicle which has a lot of acceleration, that one may say that one has to trade off to some degree the ease of driving that car with the fact that it's a very high performance vehicle which you've bought with a great degree of acceleration. Accordingly, if you deposit your high performance vehicle into a lamppost, because if you're not used to that sort of acceleration, then the court may conclude ultimately that it's still satisfactory for the purpose for which it's been supplied, given those relevant circumstances. I don't accept, however, that any car which is supplied for the purposes of being driven and used in the United Kingdom, at least a car for general road use, which this is what it is. It's not a Formula One car. It's not designed for racing round a track and only being used for that particular competitive purpose. I don't accept that a car can be satisfactory quality if it can't be parked outside, and if it may be left outside for 2 days and suffer catastrophic electronic failure. So in that regard, I'm not sure whether, coming back to my lord's original question, whether one needs to characterise it as being an absolute warranty, because we say that all one needs to do in this circumstance is just to compare what actually happened and consider whether or not the hypothetical reasonable person would consider that to be satisfactory. And we say it wouldn't. The judge, we respectfully say, was quite right. The judge said that whether it's a £12,000 runabout or a £122,000 car, it's not a satisfactory quality if it's prone to flooding in those circumstances. And the circumstances here are simply that the vehicle was left outside, parked outside in the rain. But if necessary, we do go further and we say the price means that one should expect the vehicle to be less prone to such catastrophic failure. And we'd also say that, of course, there's no suggestion in this case that any indication was given to my client as to this risk associated with the car. And in fact, it's a positive part of the appellant's case. They say in relation to their case on what might be regarded as issue 2, the satisfactory quality issue, they say that it's wrong to impose strict liability on them because they didn't know about the defect and couldn't reasonably have found out about the defect. Well, if they couldn't reasonably have found out about the defect and did not know about it, well, how could the hypothetical reasonable consumer? And
But that's the whole purpose of the Act, isn't it?
Indeed.
And I didn't hear those arguments being advanced already. Mr. Levy's shaking his head. I think I don't think that goes anywhere.
What indeed, my lord. I mean, as we understood and with respect to Mr. Levy, of course, he didn't formulate the grounds of appeal. As we understood the grounds of appeal as formulated, they cleave into two issues. One is the appeal on a question of fact. The other is a satisfactory quality issue. As I understood my learned friend's predecessor, he was putting the case on the basis that issue 2 had some independent vitality, such that even if the appeal on the question of fact failed, the position should nevertheless be that this vehicle could be regarded as one of satisfactory quality. We say that's, with respect, completely hopeless. It can't possibly be suggested that if a vehicle is subject to this sort of defect, even if it is properly serviced, according to the 12-month interval specified in this case, that it can nevertheless be of satisfactory quality.
Well, I may have misunderstood, but Mr. Levy indicated his 3 headings for today, but his 3rd heading, I didn't hear him expand on that very much at all.
Well, dear my lord, my understanding was that Mr. Levy's 3rd heading was indeed this second ground or second issue, the satisfactory quality issue, which my learned friend didn't press in oral submissions. In fact, I don't think referred to it at all, having introduced it. So I'm assuming it's not being pursued. But if I'm wrong on that, we've set out what our response is in our skeleton argument, and the highlights are this. One is to adopt, gratefully, my Lord Justice Phillips' point. The whole scheme of the Act is a strict liability. So, and the suggestion that there's some issue of law here whereby the strict liability position under SOGA with an almost identical term, it somehow is not translated into the Consumer Rights Act.
I'm not really sure why we're talking about strict liability, because it's a matter of contract, and contract is, in a sense, strict liability. If you have a contractual term, there's no mens rea in breaking a contractual term. You either break it or you don't break it.
Yes. I mean, I think the suggestion being made is that one should have a look at the knowledge or ability to identify characteristics of the vehicle on the part of my client, and that there's some necessary trade-off between aesthetics and function, which somehow modifies what would otherwise be simply the straight obligation to supply something of satisfactory quality.
Well, it's standard for contracts to contain terms or warranties, and it isn't even necessary that when a contracting party warrants something that they even believe it to be true or will be true. Warranties are often given in circumstances, for instance, where manufacturers know that the goods, a percentage of the goods will not meet the warranty. That's precisely why the warranty is given.
Yes.
There's no mental element in it at all.
Yes. Well, my lord, we agree. Perhaps in my defence, having gone down this avenue, it's a point which is made by the appellant in their original skeleton argument, paragraph 44. They complain that the judge imposed what is in terms the strict liability on the trader.
You don't need to spend very long on it.
No, well I don't. Well, my lord, we say that, and I'm not obviously seeking to criticise my learned friend. It wasn't the point that he advanced in writing, and he hasn't advanced it orally. But we say the position is that there's no substance to that point at all. But at the end of the day, the satisfactory quality issue ultimately has 2 answers. One is it's just a matter of common sense, and the judge was quite right when he said that if a vehicle can suffer catastrophic flooding in this regard when it's been properly serviced, then the vehicle is not of satisfactory quality, and that's the end of it. But the other point is that, of course, even if, my lords, you were inclined to reach a different view, or considered a different view could be reached on the evidence that's available, this is, of course, an evaluative judgment, and the court this court, with respect, should exercise similar caution to as it does in relation to appeals against a question of fact. in relation to such an evaluative judgment. The judge heard all the evidence below, and it's not for this court to second guess or carry out the balancing task afresh, which is, I think, the dictum from Sprint Room. And we've set out some of the relevant authority in paragraph 42 of our skeleton argument in that regard. In the Biogen case, Lord Hoffman said that the appellate court should be cautious in differing from the judge's evaluation. So the satisfactory quality issue, even if it wasn't answered by simply being a dictate of common sense, we say that it's territory in which the court should equally be reluctant to tread, unless some identifiable error of principle were
I suppose if all the facts are found unequivocally and the judge forms a view about how they are then to be measured against Section 9, a court could simply take the view that it's not a question of evaluation at all. You've got the facts, they are black and white, there's no dispute about them. There's a breach or there's not a breach. But here it's a very extreme situation. If the facts are as you portray them, there was a survey, there was a service carried out, nonetheless there was catastrophic damage. It's hard to then suggest that there can be any compliance with Section 9.
Indeed.
You don't really need many facts in this case to get to a marginal decision.
Indeed.
Unequivocal decision.
Indeed. And that's why we say, and it may reflect the way my learned friends approached it today, that we say that the issue 2 doesn't actually arise, because the position is that if he doesn't succeed on his appeal on the question of fact, then it can't seriously be suggested against that background that the car could be of satisfactory quality. And that's why the judge gave it fairly short shrift in his judgment as well.
If it were right that the test was subjective, then the judge might have erred. It might have made no difference at all to the overall balance.
Yes, indeed. But here we're of course dealing with the hypothetical reasonable observer or reasonable consumer, rather.
Yes.
Thank you. My learned junior, Miss Rooney, has reminded me of the passage I was thinking of, where Mr. Roberts declined to give a probability in relation to how quickly or when the drainage channel would become blocked, and that's in bundle number 2. The transcript bundle, supplementary bundle number 2, at page 199.
The speed with which there may be a blockage will be entirely context driven. If you're driving constantly through under trees which are depositing rubbish onto cars, then it may fill up more quickly if you're driving through a desert.
Well, we said that, my lord. It may, of course, also be the case that I think my learned friend criticised the judge for saying that Mrs. Kynaston-Mainwaring may have been unlucky, but that's precisely a legitimate observation, because it could be the case that the hypothetical sycamore pod, falls into the drainage channel and blocks it, or a pine cone, or a stone. But it may be that none of those things fall in, and it may be that you're driving in the autumn and there are more leaves and it fills up more rapidly. But if it were a relevant question, the evidence would have had to be adduced by the appellant, and with respect, we say that it would have been a fairly impossible task. Ultimately, it is the case which they wish to advance, which is that they wish to allege that the service was negligently carried out by Lookers in May 2019. He who alleges must bear the burden of proof, and these are subsidiary factors all related to that. They're seeking to justify that overall conclusion. We say they bear the burden, they were unable to discharge it, and the judge was right to find as he did on the basis of the evidence before him. My lords, unless I can assist further, those are the submissions we intended to make.
Thank you very much indeed.
few short points in reply. If I may, I'll just take them in the order that they came in Learned Friend submissions. Obviously, some of them are more important than others. He started off by saying that Mr. Roberts's evidence was given off the cuff. I think that was in relation, quite sure, off the cuff in relation to the point about
Hundreds of thousands.
the hundreds of thousands. And the response to that is whether it's given off the cuff or not is not really the point, because the point is the judge has found this is an expert who is an expert in design, whereas the other side's expert was more of an assessor of vehicle damage. But I've tried my very best to stick to the position that everyone was in at trial and to stick to what the judgment was. And the judgment makes a finding, and he accepts that evidence. So it really cuts both ways. From a learned friend now say, well, it was a bit of an off-the-cuff remark, it wasn't great evidence. But that was the judge's finding. And so we are, or we must...
Off-the-cuff evidence from an expert who really knows what he's talking about is still good evidence.
I accept that, but I go further and say, but it doesn't matter, because it was accepted as a finding. And I'm trying, because it's always said against people in my position, well, you're trying to re-argue the case. But I'm trying to focus on the judgment, and the judgment accepts that as a fact.
Well, I don't think it's fair to say he accepted 100,000, hundreds of thousands.
We accept 1,000.
Thousands. And the evidence that that's referring to is the 7,000.
Yes. And well, it's 2 points. One is this, the position generally of these types of cars. And the second point is specifically, Mr. Roberts gave evidence about his internet research in relation to this particular model and found nothing in relation to this. And the judge found on both of those that there are thousands of cars worldwide of this generic type, with this issue, with the drainage system. And specifically, he accepted Mr. Roberts' evidence about the internet research.
But as I understand it, Mr. Roberts' evidence as regards this type of drainage system was that insofar as it was used in the Bentley and Renault, he was aware of problems.
Well, that's my next point. That with respect, that's not right, because the problem that, and the judge certainly does not make a finding to that effect. But what that evidence is about, and my learned friend took you to page 216 of the transcripts and referred to the problem. But that was that's a problem with the front windscreen. Now, can I just show your lordship one photograph, which is, because this was explored in the evidence, in the supplemental bundle at page 50. This was a photograph of the car that was taken once it had been recovered. And there was arguments about, because effectively I think the vehicle was basically abandoned when the claimant said she didn't want it anymore. And when it was collected, it was found with, your lordship will see all the leaves gathering there. And the manual, which my learned friend took you to, which said that page 50 of the supplemental bundle. Tab 9.
Yeah, sorry, for some reason these colour photographs don't have...
No, they don't have pages.
Oh yes, they do. Sorry, very difficult to spot. Got you. It's got 04A.
Exactly. Yeah. Yeah. Oh, yes, they don't. I'm sorry. Yes. So
I see. No,
they do. Yeah.
It is in there amongst that. I see.
So, and there was an issue, and the manual, the owner's manual, which says you must clear it, is referring to that, because it was common ground that the other end of the drainage channel, the owner of the vehicle can't do themselves. So what they have to do is make sure it's cleared at the top. And then what they can't do themselves is clear it at the bottom. And what, as I understand it, what Mr. Roberts saying, it's a known problem. If people aren't clearing at the top, then you're going to get issues. He wasn't talking about problems at the bottom end of the channel.
How do we see that from what he says?
Well, what we know is that again, I'm focused on the judgment, and the judgment itself does not suggest. I mean, it says on the contrary that the judge accepts that this is not a known problem, and in a sense, one shouldn't and can't go behind that. But since my learned friend took you to that to go behind it, that was not the basis upon which the judge proceeded. He did not proceed on the basis that there is a known problem, but it's a top-end problem, and not a... He proceeded on the basis there's no problem.
We understand.
Malone Friend then made submissions in relation to the job card. Before the short adjournment, we went through the job card.
Yeah.
And again, those are points. It's always the appellant who's criticised for trying to rerun the case. Malone Friend can't do that because his case, his client's case at trial, was that those documents did not support the work having been done. I showed you what was said by the claimant's counsel in their opening. They said the documents do not support that case. Now,
Just give us that reference again.
yes.
So I'm not sure that's exactly. I'm not sure that's what it says.
That's not my recollection either.
No, I think you're, with respect, mischaracterising what that actually says. If it's the reference that I think you're referring to. We just got to be careful exactly what job we're talking about. I think from recollection, the point was being made that they didn't support that there'd been any specific investigation of the damp in the car. Okay, have you got,
Yes,
have you got the page reference again?
Yes, well, I accept that it's 168.
Yeah, there we go. Yeah, the job card does not record, the job card and electronic signature do not record any investigation or work by lookers in this respect. I mean that, so in other words, it's not saying that they accepted that a document which wasn't there, or even the ones that were there, ruled out the possibility of somebody clearing the drainage holes.
Yes.
Well,
And it doesn't. I mean, the record doesn't talk about drainage, which I think is the words in this respect.
well, they weren't being relied on. It wasn't even suggested that the documents were consistent with. So the points Malone and Friend were making were not made, and more importantly, that the judge does not. And again, I want to focus on the judgment. The judge does not say, well, it's consistent or supported. I did give your lordships before, when I opened the appeal, the reference to what Malone and Friend's predecessor said in closing, where he says that there's enough there to make a finding, but it's surrounded by unknowns. He did not make the points that Malone and Friend is putting now, and crucially, and most importantly, and crucially, the judge does not proceed on that basis.
Well, the judge doesn't refer to these documents, does he?
No.
But you did. You were the one who took us to them.
Well, I took you to them because I was showing you what the claimant's case had been, that they weren't supported. Malone and Friend then made submissions to see how you could, as if it was a trial, to say, well, there's a reference to the underside, there's a reference to this, that, and the other. But those submissions were not made at trial, and that's not the basis that the judge.
The basis the judge proceeded, as I understand it, was that he had evidence from Mr. Roberts, which he accepted, that the Mercedes operating service list, how it's described, included doing this work. And on that basis, he inferred there'd be nothing to the contrary, that it would have been done.
Yes.
And the documents that you've shown us don't undermine that conclusion at all, do they?
Well, they may not undermine it, but it wasn't being said that those documents support the conclusion. And that's Malone and Friend was saying that they are supportive, but that submission was not.
It seems to be we're slightly tying ourselves in knots here, because what we know one thing for sure: a service was done.
Yes.
It was serviced.
Correct.
Second thing we know was that the standard form of service would have included
Yeah.
doing the train.
And the judge inferred.
And that's all. That's
yes,
all there is to it.
well, I accept that.
And we can dance on the head of the pin over these documents.
Well,
at the end of the day, they don't say we. There's nothing saying clean out the drains. Tick.
No, I do accept that. So the point is that he proceeded on, and really what was on both sides of the scales, and we say that it was so overwhelming on the other side, but on that side of the scales, he said it should have been done. It was service, so I infer it was done. And that's that. Now that is how he proceeded. Now it could have been said that the documents also support the case in the way that Malone Friend made submissions. But that was not the way it was put at trial. And that's the only point I'm making, is that the judge is proceeding on the basis. Because often one says, well, he may have had other things in mind and this, that and the other. But it's rather difficult to think he had it in mind when it wasn't being said to him by anyone. He did not say that the job card, when you get to the crucial part of the judgment, he effectively said, exactly as my Lord Justice Phillips just said, he infers that because it should be done, that which ought to have been done has been done.
Yeah. Because your expert told him it should be done.
Yes, so that is why there is that on one side of the scales, and then there's everything else that we say is on the other side. Of the scales.
If there's that on one side of the scales, and you say, quote, everything else on the other side of the scale, I mean, you have to actually say that no reasonable judge could have come to any other conclusion than that what is on the other side of the scale was the right answer.
Well, I'm not sure that I have to go exactly that far.
Pretty far, isn't it?
Well, what I have to show, and I'm going to come on now to the legal test, I have to show he demonstrably failed to take into account evidence or demonstrably misunderstood relevant evidence. That was the test that you were shown. And one could characterise it as therefore as a conclusion, no reasonable judge. But the test is demonstrably failed to consider relevant evidence, or demonstrably misunderstood relevant evidence. And we say, with respect to the learned trial judge, he did both. Because he demonstrably failed to take into account, I'm going to come on to this point in a moment, the point about it being hardly used, it being kept very well, and the fact that this was the first time it ever kept out in the rain. If he had, and I'm going to come on to, because this is the crucial point I need to make in reply, which is where I say Malone Friend didn't answer this point, is he demonstrably failed to take that into account on this critical issue. And secondly, we say he demonstrably misunderstood the relevance of the lack of internet evidence. And thirdly, he demonstrably misunderstood his speculation point about well, if it's kept in the dry, that might make things worse. That was entirely, there was no evidential basis for that. So he did fail in each of those respects. I'm not sure that I would accept that you have to say, we're not in Wednesbury unreasonableness. That may be a description of what has happened, but it's a demonstrable failure to take into account evidence, and that's our point, which we say rebuts the evidence that was on the other side of the scale.
Yes.
So that's the law. Just Malone Friend said, well, let's look at the evidence on the internet research, and he said he took you to the transcript and said it wasn't really very. Mr. Roberts wasn't very. It wasn't very detailed. What he said.
You accept that was all the evidence, was it?
Yes, but I also accept what the judge said about this. And the judge deals with this at paragraphs 109 to 111 of the judgment. And I invite the court to proceed on the same basis that the judge did. Because it's often said about an appellant, well, just because you think that the point wasn't a good one, more weight should have been given to a particular point. That's too late for you to say that. But well, with respect, what's sauce for the goose, etc. Because whether Malone Friend thinks it wasn't very good evidence, the judge thought it was. At 109, he said, Mr. Roberts said he'd carried out internet research, and he'd only found this issue reference to this concluded case. He then says at 110 it would have been helpful if he'd said more about it. And then this. On the other hand, this omission, if anything, helps rather than harms the claimant. And it helps rather and harms rather than helps the defendant, simply because to know or believe that this is the case only fortifies one of the strong arguments that the defendants seek to advance. So he thought this was potentially a powerful point, and his point was, well, you can't. This shows that he's an independent witness because, and he's not. One can't impugn his independence because it's a good point, and therefore why would he not say it if it were true? And so the judge proceeds on the basis that this is a good point. At least he does at paragraph, he gives that impression at 111, but then when he comes to actually get to his critical analysis at 131, he doesn't.
He's not really, hang on, he's not really expressing a view as to the weight of this evidence. He's dealing here with criticisms of Mr. Roberts. Isn't he really just saying the fact? Sorry, let me just get this straight. Yeah, he's dealing with whether this is indicative of a lack of objectivity on Mr. Roberts' part, isn't it?
Yeah. Yes, but the reason he says it doesn't show a lack of objectivity, because he said why would an expert not say something which is potentially a strong point in the other side's favour? That's all.
This is responding to criticisms of
Yes.
Mr. Roberts. I mean, the only relevance of all this is the second sentence of paragraph 132, and it's whether he's right to basically treat this as neutral.
Yes, well,
Or it's not indicative or not terribly helpful to him either way.
Yes, well, I accept that, but because my learned friend was trying to say, well, the evidence itself wasn't, it was only an off-the-cuff remark. The judge was taking it at face value. That he'd done. We don't know how long the internet research was. There was no cross-examination about how many searches and how long did your searches take.
Maybe that's exactly why the judge thought, well, I can see it could swing both ways, but frankly, it doesn't assist me a great deal.
Well, he said that this is an impressive witness who knows about this. He
might have done, but his the probative weight attached to it is that which he gives in 132.
Yes, and the answer is he gives it 0.
Whilst there is no evidence of any other example of this, that does not lead to the conclusion that this is the only case in which it has ever happened. So,
yes, but
A cancels out B.
Yes, and our complaint is, even if one doesn't think it's a killer point, the idea that it really tells you nothing has a lack of reality about it.
Okay, with that, we understand
You know,
the criticism you've made, which we fully understand, which we'll obviously need to consider, but we understand the point.
And we say that the judge demonstrably failed to understand the relevance. Yeah. I'm not suggesting, as I say, it's not a killer point, but the idea that it's of no effectively neutral is demonstrably wrong.
Yeah.
My learned friend said that we had 4 points. Essentially said boiled down to 4 points. He missed out the 5th point, which was that the first time that the car was left out in the rain for 2 days. He did give a list of 4.
I thought that was part of his passage of time issue.
Yes, exactly.
Or the vehicle was well looked after issue.
Exactly.
I rather fell within one or both of those.
But the 5th point is that this was on the claimant's own evidence the first time it was left outside in the rain, and that is a very important point which is not taken into account. Now, I can then just.
I find this a bit slightly difficult to understand because your case presumably is that even if the car is left outside, exposed to pollutants and to rain, 365 days a year, it's of satisfactory quality in this regard, so long as it is serviced every 12 months. That has to be your case, I think.
It is my case.
But then you say, well, in this case, the car wasn't outside exposed to any elements or to any rain for most of the period between May and November. Well, isn't that a point against you ultimately? Because it shows that, in fact, despite the fact that this car wasn't outside for that period, it suffered this problem in November.
My lord, no, because you have to get yourself to the right factual position. The factual position was there was an issue in February or April which was not dealt with. And that's one of the. And I'm going to come on to this.
It was looked after in the same way at that point. There's no suggestion that it was kept outside in February.
Your original submission was this casts a light backwards upon what happened earlier on, whether there was service or not.
Right.
The way you advanced it when you were opening the appeal was that this casts a light backwards on whether or not there was a service properly conducted in the earlier part of the year.
Yes.
And that's the only relevance of it. Does it have much relevance beyond that? judge should have inferred from that.
So what Malone Friend called the passage of time point, and Lord Justice Phillips, with respect, was right to say that Malone Friend wasn't really meeting the point. With respect, Your Lordship was.
You can say it, don't worry.
Was wrong to say that it may not be a good point. We say it's not just he didn't have an answer to it, but it's also a good point to which he doesn't have an answer. But it has a twofold significance. The first point is that it shows that it can't have been cleared.
We understand.
The second point is it's an answer to the judge's question that he posed for himself. The judge said, 131. Well, if it hadn't been cleared, how come it took till November to happen again? So he had, in Lord Justice Phillips' words, the ready answer to his own question.
Mm-hmm. Okay.
And so
two relevances.
It's got two relevances, and neither of them are referred to, and that's a demonstrable failure to consider the issues, because he posed himself the right question. Because there is obviously
he failed to realise he had the answer.
Yeah, and he doesn't even suggest that might be the answer. And the second point, as I say, or the first point is it shows that it can't have been cleared, because otherwise, with such little use and kept so well, how did it happen? When it was driven, and I think Your Lordship gave a reference to September. I think probably a slip. I think the relevant figures are 1,287 miles between 8th of May and 22nd of November. So it really was barely driven, kept well, and left out in the rain. That's the crucial point. And the judge does not, when he poses his question, which is with respect to the right question, he does not say, oh, well, perhaps it's because it was fairly driven and then left out in the rain. So in other words, the problem that existed in April and May was never cleared, presumably got worse because the debris is decomposing, which I think what the experts say, and then it's left out in the rain, and then there's a flood. So he had the answer, and he didn't consider it. Now, there was a very important point with respect that Malone Friend made. He came close to, he made a concession, obviously not on our facts, but he said, if it had been taken off the road, I accept the force of the point and the judge didn't take it into account. Now, of course, I can not say it was taken off the road. But it was pretty close to it. It was pretty close. It did 1,200 miles in 6 months, never ever, on the claimant's own evidence, left out, and then left out for the first time between the 20th and 22nd November in the rain. So, although Malone Friend, he would say, well, it wasn't taken off the road, he accepts the principle of the point, and we're very close.
Well, 1,200 miles isn't nothing. I know it's not heavy mileage, but that's not remotely the same as being kept off the road. That's an average of at least 10 miles a day, isn't it?
It's a bit more nuanced than that, though, with respect, because you have to look at the claimant's own evidence, and her evidence is she wasn't using it to go to the shops. She would take it out when it was nice weather, with the wind that she wanted to put the roof down. So it's not like it was being used on a day-to-day basis on a commute or something like that. When I accept that's 40 or 50 miles a week, but her evidence was I only really took it out in nice weather. So I would actually look at the weather. It's not like I've got to go to work and I'm in the car and I'm going to get wet. Oh, it's raining. I won't take the car. I'll take the Land Rover instead, or the Range Rover, whichever the other car was. So no, it's not off the road, but she's deliberately only using it. That was her own evidence. I showed you in the transcript. I only really took it out if the weather was nice, and it's the first time I ever left it out. That's quite extreme. I wouldn't suggest there are many people who literally will keep the car covered with a silk sheet and only take it out when the weather's nice.
Yep.
That's the point. Malone Friend then, he looked at paragraph 129 of the judgment. So this is the bit where we say the judge went wrong.
This is about problems can arise in periods less than 12 months.
Yes, But there's a completely false equivalence here. Because we do know there was a problem between May 18 and February/April 19. But not a catastrophic failure, not a flood. What we have is
So
some
you say he's taking into account an incorrect comparator.
Exactly.
That's the point.
Because there's some misting and some dampness.
Right.
Now, my learned friend then says, and this is, and now just a couple more points. If I dislodge the facts on May 19, my learned friend says, well, my fallback position is it's still not a satisfactory quality. He said, would a reasonable observer looking at these facts think it's satisfactory that you can't leave your car out in the rain without it flooding? But that's the wrong question, because the world we're in now is that there was a problem which did arise, some misting and some dampness, and it should have been cleared. So, of course, if it's properly maintained and it floods, then I'd be in difficulty. But that's not what happened. What happened here on these facts is that from May 18 to February and April, there was a build-up and there was some dampness. That's all there was. So it's completely, it's inaccurate to say, yes, it was said 2 days in the rain and there's catastrophic damage. Is that satisfactory, is what my learned friend said. Well, that's not the right question.
But it's accepted that it was a blockage.
What the judge found is there was some blockage.
But it's a binary, isn't it? Either it's blocked or it isn't. If the water is not blocked, the water will drain through.
Well,
it's only going to come into the car if it's blocked.
I'm not sure about that because one can have if the exit is partially blocked, you could have a blockage enough to have some moisture without it necessarily being.
It depends how hard it rains.
Yeah.
I mean, if it's fully blocked, it doesn't have to rain very hard. It'll still overflow. If it's partially blocked, it might have to rain quite a lot harder before it overflows. But
and I fasten myself on the judge's findings, and the judge's findings, and this is all we have, is there was some misting and some dampness. And one can, in the way my learned friend rhetorically asked, well, what would a reasonable observer say? Let me ask this rhetorical question: if with some dampness on the carpet and some misting, and she'd taken it back to my client and said, "Thank you very much, not a satisfactory quality. I'm leaving it in. I want my money back." Would it really be said that it's not a satisfactory quality? And that's my issue too. So and there was a debate between my learned friend and the court in relation to those sorts of issues about Section 9. But you have to put yourself in the world that we're in. Could you just say, I'm having the car back because there's some dampness? In circumstances where on this hypothesis...
the conversation wouldn't stop there, would it? It would.
Well, it would be clear.
Somebody would say, well, no, somebody would say, look, I'm not having a car which lets water in. And why, madam, you should be satisfied with it. The answer is, because it could get worse. It shouldn't have got wet now. I mean, it's not just a binary.
Well, but with respect, that wouldn't have been the answer. The answer would have been this is a very unusual thing, but we can clear it, and we'll clear it, and that will be the end of the problem. That's the evidence. The evidence is if it's cleared and properly maintained. So yes.
No, but it's just like false basis, isn't it? Because of course, if it had been appreciated at that time that was being caused by a blockage, it no doubt blockage should have been cleared. But the question is are those incidents indicative of the fact that something could happen ultimately as catastrophic as happened in November? And we know that at the end of the day, something as catastrophic as happened in November did happen in November.
But because it wasn't properly maintained.
Well, that is the question.
I agree with that, but my learned friend has got a fallback position. He says even if it was properly maintained, because of what happened in February and April, that's enough to show not a satisfactory quality. So that's the point I'm on now. If it wasn't properly maintained and you had some water, some moisture in February or April, could you go back to and say, sorry, this isn't satisfactory?
I think the point is that if it can happen to that extent in February and April, particularly in February, then we now know that a worse version of that is what happens in November. And I think the point is, if it can happen that badly in February and April, it can happen as badly as it happened in November.
Well, I respond in two ways. When your lordship said it can happen that badly in February and April, but the point is, in February and April, it wasn't that bad.
Because there probably wasn't enough rain, or it wasn't hard enough, it wasn't left out long enough.
There was.
I mean, as I understand it, you're saying to us that this vehicle was hardly left outside, and that was the same in February and April as it was in May to November.
Yes.
The points you make about May to November equally apply to February and April.
Well, not quite, because it was. We know it was driven a lot more, because we know from the time she had it. I think it was.
But it wasn't kept outside.
Yes, but it was driven more. I think it was.
And you have to satisfy, or the judge had to be satisfied that this vehicle was satisfactory, even if kept outside 100% of the time.
Yes. So the first point is that the judge never got to answering this question, because he was answering it on a different basis, which I say is the wrong basis. He says it had been cleared and it happened twice, and it's prone to flooding. There's an undue risk. So he's not answering the question I'm inviting, which now arises if I were to succeed on ground one. The question then becomes: is it of satisfactory quality? The fact that you can have some issue with dampness, which on the evidence did not cause any significant problem, and which, if properly maintained, would have been dealt with. And on that, we would say, things happen. Yes, there was a problem. That does not mean that this luxury vehicle was, given the compromise and the payoffs between the style and the design, etc. That doesn't make it unsatisfactory quality. And then, just one other point on that.
This is just to make sure. Sorry.
Yes.
This is all on the basis that you're wrong on ground one.
No, I'm right on ground one.
Sorry, that you say. Sorry, yes, that you're right on ground one, and even if the cause was lack of proper maintenance or lack of the carrying out of the service in May 2019.
So, if I'm right on ground one, then it was cleared. Then it wasn't cleared.
That's sorry. I'm just trying to.
Yes.
So I've lost the hypothetical.
And what my learned friend says, and this was the other side, and this was the other side's case. This is why they said it's a distraction. I showed your lordship that in their opening, because they said the fact is there was a problem in February and April. Ergo, it's not satisfactory quality. But that's the flaw, because what there was in February or April was, and it's regrettable, some minor, relatively minor problem, which if properly dealt with, would have been cleared. So you can't say that it's not satisfactory quality just because an issue arises. And that brings me...
so the hypothesis is that you're right on your first ground.
Yes, I have to be right on that.
Yes, sorry. Okay,
I have to be right.
fine.
And then that brings me almost finally to your lordship's point about satisfactory versus warranty. It is coming quite close. If the argument is that because of what happened in February and April means it's not satisfactory quality, it's coming quite close to a warranty. And of course, the important point is that manufacturers such as Mercedes offer 3-year warranties, or like all vehicle owners. And of course, the point of a warranty, and that's why it always says on the till, it says, this does not affect your statutory rights. The warranty is going further. The warranty is basically saying, if there's a problem, we are going to deal with it. You don't have to start proving that it's not satisfactory quality. But the fact that there can be a problem which will be fixed under warranty does not mean, it's not a satisfactory quality. That is bringing it pretty close to it being strict liability. I agree with your lordship, it's not the right way of referring to it, but it's coming close to warranting that this will be defect-free. And that's why one has a warranty. That's the point of a warranty. Gives you over and above your basic statutory rights. Manufacturers don't have to give warranties, but they do it to give people comfort. So if I'm right on my first point, then what happened in February and April was not unsatisfactory quality, and then I'm not pursuing the point that it's not a legal argument about strict liability. I'm not pursuing that. I did have a double fallback position, which I refer to in openings, that even if it happened twice, that's still not a that still doesn't mean it's not of satisfactory quality on the basis that things happen, and here things happen twice. They had the benefit of a warranty, which Mercedes have not honoured, but that warranty would or ought to have dealt with this point. And so even if it did, even if lightning did strike twice, my submission, which I abandon, sorry, I don't abandon, but I only advance very lightly, is that it's still not of such satisfactory quality. But I rather get.
But you didn't advance that orally earlier today.
Yes, I did say that earlier today. Yes, I said it in an opening. Said I'd see how it goes, and I don't think I said very much, or if anything, about it beyond that.
Well, you said it was a heading, but you didn't actually then.
Well, I think I was. Yes.
I think just be careful, because I don't think Mr. Weeks dealt with it as a result.
Well, I think he was dealing with the point that Mr. Barkley was making in terms of a legal argument. We're not running that. There is. It is conceivable that the court could say, even if this problem was cleared and it did happen twice, that still the court could say that that's still not of satisfactory quality. Sorry, that is still yes, not a breach of Section 9. But I.
So you are. Sorry, I just want to make sure I answer. You are still advancing it, but faintly.
Yes, I'm not abandoning it. I rather suspect if I haven't persuaded your lordships on ground 1 and ground 2,
You ain't going to get home.
I don't think ground 3 is going to save my client. If my friend wants to, well, it's a matter of the court.
We'll deal with it this way. If anything arises in which we need this further submissions of the parties on that, we will not give a judgment until such time as we've heard from the parties. So let's see where we get to on that.
Unless I can just further.
Thank you very much indeed.
My lord, sir, I'm quite content with that position. Just to make one clarification, my learned friend has referred to the evidence of my client in relation to the car being left out in the rain. It's important not to mischaracterise what her evidence actually was that she gave in her witness statement. What she says in her witness statement at paragraph 40 is normally when I drew, and this is in the supplemental bundle 1, page 139, normally when I drove the Mercedes back home, I would park it in the garage unless I was going out in it again that same day. But because my mother was elderly, I parked outside the door where we leave the other vehicles, and we went inside. I then had 2 or 3 really busy days with work, and so I left the car outside for those days. This was the first time I'd left the car outside overnight. So she didn't give evidence in her witness statement that it was the first time she'd left the car out in the rain. And we know that she did leave the car in the rain, for example, in February when she went out for lunch, and then when they came back to the car, it had misted up due to the rain. It is right, however, to say that in paragraph 31, she does say, I can recall that it was raining on the day, as by choice I would not take the car out in rainy weather. But as far as I'm aware, my client didn't say. The position is that the first time she left the car out in the rain was in November 2019. What she was actually saying was the first time she left the car out overnight. Yes. Thank you, Mama.
Well, thank you all very much indeed. We are not going to give an extempore judgment. We will reserve judgment in the ordinary way. When you receive it from us, you're entitled to make submissions on editorial matters only. You're aware of the new terms of the embargo. We are required to warn you of the serious consequences of failing to respect confidentiality. We will get judgment to you. It will almost certainly be after the summer now, won't it? I think all that remains is to thank counsel very much indeed for all your assistance. It's been an interesting case. You'll have seen it's been quite enjoyable to actually deal with cars for a change. So thank you all very much indeed.
Thank you.
Thank you.